You're listening to Women's Media Center Live with Robin Morgan.
Welcome to Women's Media Center Live. I'm Robin Morgan. Well, Americans are not totally aware of it, but there is still a world out there, you know. As only two examples, tens of thousands of women took to the streets in dozens of Polish cities and towns for a national strike on Wednesday to protest a top court's decision to ban almost all abortions. And meanwhile, the nation's leading politician, Jarosław Kaczynski, the deputy prime minister and leader of the ruling Law and Justice Party, called for his conservative supporters to defend Poland against criminals seeking to destroy the Polish nation. Meanwhile, the women interrupted Mass, took on the Catholic Church, vandalized church facades, staged sit-ins at cathedrals, and held coat hangers aloft, which we used to do, to symbolize dangerous abortions. You go, sisters. And in Qatar, well, the government there expressed regrets for having detained women on a total of at least 10 flights. In flights from Doha to Australia, to subject them to invasive medical exams after an abandoned newborn was found in an airport bathroom. The women were outraged. The Australian government protested, but the episode highlighted the treatment of women in Qatar, where sex, pregnancy, and childbirth outside of marriage are all criminalized. That gives you a taste of the rest of the world. Here, of course, oh my God, it's only 2 days until the election. Although some of us voted early and others have been voting by mail, and all of us are chewing our nails. Our main task, if we haven't done so already, is to vote. No matter how long the line is, no matter how hard it's raining or cold, no matter how they try to intimidate or discourage us, vote, 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 and breathe. Be as calm as possible while waiting for what likely won't be results on the night itself. We have to remember that our people are superbly prepared on all fronts, from peaceful marches to legal actions. So, today's program follows the new formula of focusing on one subject in what I call the In-Depth Civics for Grown-Up People series. Today, the topic is the United States Supreme Court, because frankly, whatever happens on Election Day or thereafter, we appear to be stuck with a new, young, arch-right-wing conservative associate justice for life, who will likely affect our lives for at least a generation in seriously deleterious ways. She was rammed through by Senate Majority Leader Mitch McConnell against tradition, precedent, common sense, and in the teeth of his having blocked President Obama's last appointment to the court for almost an entire year before an election. This time people were already voting when she was sworn in. So we are doing the United States Supreme Court. And my special guest is former New York State Supreme Court Judge Emily Jane Goodman, longtime friend, sister, and distinguished colleague. So we better get started by going inside the headlines. Any history of the court is an exercise in acute compression, sort of around the world in 80 seconds. Here goes. It was while debating the separation of powers between the legislative and executive branches that delegates to the 1787 Constitutional Convention established structure for the national judiciary. Creating a third branch of government was a new idea. In the English tradition, judicial matters had been treated as an aspect of royal executive authority. Early on, delegates who were opposed to having a strong central government argued that national laws could be enforced by state courts. Others, including James Madison, advocated for a national judicial authority consisting of various tribunals chosen by the national legislature. It was also proposed that the judiciary have a role in checking the executive power to veto or revise laws. Well, finally, the framers compromised, not delineating the exact powers of the Supreme Court or the judicial branch's organization as a whole. So, established by Article 3 of the United States Constitution, the composition and procedures of SCOTUS were initially forged by the First Congress in the Judiciary Act of 1789. When Washington signed the act into law, he set the number of justices at 6, a chief and 5 associate justices. The Supreme Court, the country's highest tribunal, was to sit in the nation's capital, at first New York and later Philadelphia, before, finally, Washington, D.C. The act also divided the country into judicial districts, which were organized into circuits, and justices, assigned specific districts, were required to ride circuit and hold circuit court twice a year. So they were on the road a lot. Now, the court originally had only 6 members, but Congress allowed less than the court's full membership to make decisions, starting with a quorum of only 4 justices in 1789. Apparently, nobody cared too much about breaking a tie. The court lacked prestige, but its power grew during the Marshall Court. That's 1801 to 1835. Chief Justice John Marshall had charm, humor, high intelligence, the ability to form coalitions, and a forceful personality. Not for nothing has he been called the Great Chief Justice. He wrote almost half the decisions during his 33 years in office. And under Marshall, the court established the power of judicial review over acts passed by Congress if unconstitutional, specifying itself as the supreme expositor of the Constitution in Marbury v. Madison. It also shaped the balance of power between the federal government and the states, including the Interstate Commerce Clause and the creation of a national bank. It's Congress, not the Constitution, that decides the size of the court. Only since 1869 have there consistently been 9 justices. Before that, Congress routinely changed the number of the justices to achieve political goals and to accommodate additional states joining the Union, resulting in as few as 5, as required by law, under John Adams, to as many as 10 under Abraham Lincoln. In Adams' case, he and his Federalist Party longed to deny Jefferson, who had just won against Adams in a presidential election, a Supreme Court pick. So Adams nominated John Marshall, and Congress confirmed him in 1801 to replace Chief Justice Oliver Ellsworth. Adams then went further and passed the Judiciary Act of 1801, which decreased the number of Supreme Court justices from 6 to 5, thus lowering odds that Jefferson could ever nominate a new justice during his term in office. In response, Jefferson and his new Congress promptly repealed that Judiciary Act, bringing the number of justices back to 6. The Taney Court, 1836 to 64, is primarily remembered for its awful ruling in Dred Scott v. Sanford, which helped precipitate the Civil War. Dred Scott, an enslaved man from Missouri, sued for his freedom on grounds that he had been taken into Illinois and Wisconsin, both of which prohibited slavery for extended periods of time. The court ruled, however, that members of the, quote, African race, unquote, were not and never could become citizens of the United States, and that Scott had no standing to file the lawsuit. Additionally, Taney held that the Missouri Compromise, under which Congress prohibited slavery in certain territories that formed part of the Louisiana Purchase, was unconstitutional. Well, the ruling was met with fury from abolitionists and helped lead to the Civil War. During the war, the number of justices increased to 9 in order to cover additional circuit courts in the expanding American West, and Abraham Lincoln, incensed over the court's 1857 Dred Scott decision, added a 10th justice in 1863. After Lincoln's assassination, in order to limit Andrew Johnson's power since he was rapidly destroying plans for Reconstruction, Congress passed legislation that cut the number of justices back to 7, all but assuring that Johnson could not fill a vacancy. Then, when Ulysses S. Grant was elected president in 1868 with the backing of congressional Republicans who hated Johnson, as a gift, Congress increased the number of justices from 7 back up to 9. In the aftermath of the war, Congress passed and the states ratified the 14th Amendment, which, among other things, prevented states from abridging the privileges and immunities of citizens, from denying due process of law, and from denying equal protection of the laws to any person. In the Reconstruction era, the Chase, Waite, and Fuller courts, they range from 1864 to 1910, interpreted the new Civil War amendments to the Constitution and developed the doctrine of substantive due process. But later on, in Plessy v. Ferguson, 1896, the court under Chief Justice Melville Fuller ruled that the Equal Protection Clause did not prohibit racial segregation in public facilities, thus giving rise to the infamous term separate but equal. Under the White and Taft courts, ranging from 1910 to 1930, SCOTUS held that the 14th Amendment incorporated some guarantees of the Bill of Rights against the states in Gitlow v. New York. It also grappled with new antitrust statutes, upheld the constitutionality of military conscription, established the 14th Amendment as protection of the liberty of contract, and controversially overturned numerous state and federal laws designed to protect employees. In 1937, after a landslide election, Franklin Delano Roosevelt tried to expand the court, proposing the appointment of 1 additional justice for each justice who had reached the age of 70 years plus 6 months and who had refused retirement to take retirement at full pay up to a maximum bench of 15. The proposal, ostensibly to ease the burden on elderly judges, was widely understood as an effort to, quote, pack the court, with justices who would support Roosevelt's emergency New Deal legislation to combat the Great Depression. Well, the plan failed in Congress, but the court's balance began to shift anyway, and by the end of 1941, Roosevelt had appointed 7 justices and elevated Harlan Stone to Chief Justice. In the New Deal era, the court under Hughes, Stone, and Vinson, 1930 to 1953, gave a broader reading to the powers of the federal government. But the flip side to the courts favoring government power was that it also upheld the constitutional violation of interning Japanese American citizens in camps during World War II in the case of Korematsu versus the United States. In 1983, a federal judge overturned Korematsu's conviction in the same San Francisco courthouse where he'd been convicted as a young man, but the Supreme Court's repudiation, issued as part of a ruling on Trump's 2018 Muslim travel ban, was declared a devastating whitewash by Justice Sonia Sotomayor and Justice Ruth Bader Ginsburg. The Warren Court, 1953 to 1969, unanimously declared that segregation in public schools violates the equal protection law of the 14th Amendment, Brown v. Board of Education, reversing the precedent set earlier in Plessy v. Ferguson. The court dramatically expanded the force of constitutional civil liberties, ruled that legislative districts must be roughly equal in population, created a general right to privacy in Griswold v. Connecticut, limited the role of religion in public school, required the right to appointed counsel, and required a criminal suspect be apprised of all these rights by police. That's in Miranda versus Arizona. It also limited defamation suits by public figures in the New York Times versus Sullivan, and it supplied the government with an unbroken run of antitrust victories. The Burger Court, 1969 to 1986, marked a conservative shift, but it expanded Griswold's rights to privacy to strike down abortion laws in Roe v. Wade. It was divided on affirmative action, campaign finance regulation, and the death penalty, later ruling that the death penalty itself was not unconstitutional. Yet it did establish a moratorium on capital punishment, holding that states generally awarded death sentences arbitrarily and inconsistently, although the moratorium was lifted 4 years later. And in the United States versus Nixon in 1974, SCOTUS ruled that courts have the final voice in determining constitutional questions and that no person, not even the President of the United States, is above the law. The Rehnquist Court brings us up to 2005, generally conservative, although not by today's far-right standards. It tended to emphasize the limits of the Constitution's affirmative grants of power. Nevertheless, it upheld affirmative action, declared flag burning a form of speech protected by the First Amendment, and sanctioned student-led school prayers as unconstitutional, voided laws prohibiting late-term abortions and laws against sodomy as violations of substantive due process, and struck down single-sex state schools as a violation of equal protection. Most of the liberal decisions were triggered by the swing vote cast by Justice Sandra Day O'Connor, the first woman ever to serve on the court. The court's decision in Bush v. Gore, ending the electoral recount during the presidential election of the year 2000, was, to say the least, controversial. The Roberts Court is regarded as considerably more conservative than the Rehnquist Court, although its ruling on marriage equality, Obergefell versus Hodges, was notable. But it has moved further to the right in decisions about climate change, campaign finance regulation, Citizens United, gun rights, the death penalty, and much more. The court has recently ruled that Trump can shut down the census count ahead of time, despite fears about an undercount. It is also an increasingly pro-religion Supreme Court in an increasingly secular nation. This, combined with two other elements, makes for a gravely lopsided judicial system. One, Senator Mitch McConnell has appointed literally hundreds of young, many unqualified by the Bar Association, judges in the general federal system, some of whom have never tried a case. They will be there for years. And two, the confirmation of Amy Coney Barrett to the Supreme Court itself shifts the balance wildly, from 5 to 4, when and if Roberts decides to be a swing vote, to 6 to 3, which means it doesn't matter, even if he does become a swing vote. It's all been tediously incremental and agonizing, steps toward a more perfect union. We have a lot of work to do. Time for our first break, but there's a lot more to come. There's Judge Goodman coming up, and there's Fighting Words, of course, but right now, what we have to do is go into the surrealism corner. Subscribe to this program on your favorite podcast platform and leave us a review. Follow us on Twitter at WMC Live, like our Facebook page at facebook.com/WMC Live, and visit us at WMCLive.com for more information about our show and our guests.
You're listening to Women's Media Center Live with Robin Morgan.
Given that Judge Amy Coney Barrett is now Justice Amy Coney Barrett, we know we must be in the surrealism corner. After all, her track record reveals her recent decision to reverse a verdict that awarded damages in a sexual assault case, and lots of dissents to rulings that invalidated anti-abortion laws, and opposition to contraceptive coverage in the Affordable Care Act, and opposition to marriage equality, and considering climate change just too controversial to address, and considering the right to privacy too controversial to address. That's just some of her track record, but I'm sure we'll get to see lots more as time goes on. Let's take a trip down memory lane, though, and look at what has happened in the past with the court. A whole little series of factoids. For example, 4 U.S. presidents never had the opportunity at all to appoint a Supreme Court justice. William Henry Harrison, Zachary Taylor, Andrew Johnson, and Jimmy Carter. U.S. Supreme Court Justice John Rutledge, the second ever to hold the position, was also the only person ever removed against his will. His departure was due to a controversial speech he gave that denounced the President Washington-supported Jay Treaty. That treaty was not acceptable to him. He, however, later tried committing suicide by jumping off a wharf, but he was fished out by 2 enslaved men, kindly enough to do so, before he could drown. William Howard Taft is the only president to have served on the Supreme Court. He left the White House in 1913 after 1 term as president, and he reemerged in 1921, as Chief Justice, a position he held until 1930. He was the one who said, "Presidents come and go, but the Supreme Court goes on forever." The very first Supreme Court did not issue a single ruling. Only 5 of 6 posts had been filled, only 4 justices convened at all, and nothing happened. Justice Joseph Story was the youngest ever to take the post at just 32 years old. He served 33 years from 1812 to 1845. He was the one depicted in the Steven Spielberg film Amistad, and in that film he was played by retired Justice Harry Blackmun. For the first 146 years of its existence, the Supreme Court had no building of its own. Justices met in different rooms of the Capitol building, and they also frequented private homes and bars and boarding houses where they stayed to discuss their cases, since they were traveling around the circuits so much of the year. Justice James Clark McReynolds is today perceived as one of the most bigoted justices ever to serve. Highlights of his bigotry includes referring to an all-black university as an N-word university, while having his hair cut by an African-American barber, and making frequent anti-Semitic comments. He was generally loathed by the rest of the court, and when he died, no one, not a single colleague, attended his funeral. Justice Hugo Black holds the distinction of being one of the longest-serving justices with a 34-year tenure. He was also the only known member of the Ku Klux Klan ever to sit on the court, though he later said he regretted it. Oh, well, he regretted it. Perhaps the new justice, maybe she won't be such a shock to the system after all. How surreal. We have to take a short break here, but I'll be back directly with my special guest for today's conversation. The former, now retired, so she can really tell the truth, Judge of the New York State Supreme Court, Emily Jane Goodman. That's coming right up. The Women's Media Center, founded in 2005 by Jane Fonda, Gloria Steinem, and myself, is a progressive, nonpartisan, nonprofit organization working to make women visible and powerful in media. You can learn more about the WMC at womensmediacenter.com.
You're listening to Women's Media Center Live with Robin Morgan.
My guest for the conversation today is Emily Jane Goodman. An early feminist lawyer, Emily Jane Goodman served as an elected New York State Supreme Court judge for over 25 years. Prior to that, she was a judge in the criminal and civil courts, and she now practices in New York and frequently writes about women and legal affairs for the New York Times, The Nation, Newsday, and she's a regular columnist for GothamGazette.com. Emily Goodman, Judge Goodman, was my sister and partner in the founding of the New York Women's Law Center in the early 1970s, and she was my counsel, my attorney, in the lawsuit that Ted Hughes brought against my first book of poems and Random House for having implied in a poem that he was culpable in the death of Sylvia Plath. Here is former New York State Supreme Court Judge Emily Jane Goodman. Emily Jane Goodman, welcome to the program.
It is wonderful to be here, to be with you, Robin.
Well, listeners, full disclosure, Judge Emily Jane Goodman of the New York State Supreme Court was 1,000 years ago and yesterday my lawyer. She was my lawyer in the famous or infamous Grove Press seizure and occupation. She got me out of jail. She was my lawyer in the setting up of the very first feminist fund, Sisterhood is Powerful fund, with the royalties from the anthology. And we have stayed in touch all these years. Well, we're talking about the Supreme Court today of the nation. But I'm throwing it open to your thoughts on many different fronts. We have a new justice now, and a justice who is a throwback to, I don't know even how far back to go. Times you have to go before the American Revolution. And that presents a problem, and people are running around saying, does this mean we should expand the court? Does this mean we should stay at the same level? Does this mean we should impeach? And so what are your thoughts on that?
As far as the number, I don't think that that's really the issue. And as far as what should we do going forward, I think right now, just before the election, it's a bit of a diversion from the myriad problems that are already on the table. Nothing can happen in the immediate future, of course, except for having a new Supreme Court justice. But I think it's simplistic to say, well, we should add two more people, two more justices to the bench, because there's no end to that. Then the next time the administration changes again, you can add some more and keep going tit for tat. It's a very, very complicated issue, and I think it really requires structural change and to recognize that the Supreme Court is not just about being a shield against tyranny and protecting the public from the king, as it were. It's not the Madison vision or version, but really the Supreme Court is a legal and political institution. That's not what we learn in grammar school.
No.
It's not an independent co-equal branch of government, but it is part of the political leadership. And therefore, in addition to interpreting law, it's making political policy. And that's what we tend to overlook. It confers legitimacy on the policies of whatever coalition happens to be in power, with some notable exceptions, judges who did do surprising things. In none of these institutions do we have a representative, one person, one vote institution.
Right.
We have, and the last Republican president was also not elected by popular vote.
Mm-hmm.
And you've already talked extensively recently about the Electoral College.
Yeah.
So we know who put the president in power.
Yeah.
And in office. And then the Senate is not a democratic institution, because we know that each state has 2 senators, regardless of the size of the state.
Mm-hmm.
So New York and Wyoming have the same number of people in the Senate. And it's heavily weighted toward the West and toward the less populated states.
Mm-hmm.
So since they are the ones who have to confirm the nomination of the president, and if it's the same party, Republican president, Republican Senate, you know what's going to happen.
Yeah.
So it's not just who is the best justice to be on the court.
Mm-hmm.
It's the party loyalty, and you will have a majority that will be making policy in accord with the coalition that's in power, the president and the Senate. And they will, the majority of the court, and now we can pretty much look at 6-3 decisions.
Yeah.
They are interested in what the elite power forces want. And the elite power forces want whatever keeps them in power.
Yeah.
And given that the current president was not elected by the popular majority, nevertheless, the court is tilted toward what this power elite wants, and they have the opportunity that there will be basic shifts over the years in the distribution of rights and liberties of people. They will reflect how they got there.
Mm.
And they only deal with cases of fundamental importance for the most part. They have very, very small caseload. They take very few cases. That is one thing I would say in favor of increasing the number, because then they could take more cases. They take so few cases.
Interesting.
As is. But that point, I do not hear in the conversation about increasing the number. It's only increasing the number in terms of the distribution of power, not the distribution of work. So anyway, now we have justices appointed by a president who was not elected by the people,
Mm-hmm.
A Senate which is not a one-person, one-vote representative institution,
Yeah.
and as I said, is not a shield against a tyranny, but is there to confer legitimacy on the policies of the coalition that happens to be in place. And so there needs to be an end game to disputes, but the Supreme Court legitimizes the actions and reaches resolutions of disputes in accord with the agenda of those in power and those who placed them there.
Let me ask you something, in fact, about that, because leaving aside for the moment the idea that, yes, this is a diversion before anything is before the election, but Biden has suggested that he would set up a bipartisan good luck with that. But somewhere find a bipartisan people to serve on a commission to examine the entire federal justice system, including all of those hundreds of lower courts that Mitch McConnell has packed, quote unquote, packed with people who are very white, very male, very inexperienced, and very young, and they're there for lifetime appointments. So does that kind of thing seem like a good idea to take on the entire judicial system, or is that court system, or is that biting off more than anybody can chew?
Well, some things would require constitutional amendments. I mean, like a constitutional convention.
Oh, dear.
And that in itself is risky.
Very.
Because the constitutional convention, we could lose what democracy we have.
That's right.
The whole thing is so politicized that you might as well look at everything. I don't think that would happen. Because I don't think anyone is really ready for major constitutional change all around, and I don't think you could have one branch without the others.
Okay, let me ask you something else. Although it's very true that as the years go on, justices vote the way that the reason that they were put on the court for, it's also true that there have been some notable shifts. I mean, I can't remember who was who because one was black and one was white. That was their names. But one went to the left, coming on as a right winger, and the other one came on as a left winger and went to the right. And in fact, Roberts himself is no dummy. I mean, he knows that the courts get named after their chief, and I think he doesn't want the Roberts Court to go down in history as a crazy conspiratorial right wing. I don't think climate change is real court. So that, I think, may account for some of his recent, I would hardly say progressive, but at least progressive-leaning decisions, when he was the swing vote, which won't even matter anymore because it's 6-3, not 5-4. But what do you think about those possibilities of people changing?
Well, look, I mean, Roberts has a nice smile. But he is a hardcore conservative, and in recent cases where he seems to, where he is voting with the liberal wing, if you will, it's on very, very narrow grounds that he knows are not going to be permanent.
I see.
Like the recent abortion case, the most recent June.
Yeah.
Where he said, well, he's following precedent, meaning the case before, which he felt was wrongly decided. So he said, so I'm stuck in that position, and now he's just going to wait for another case to
deviate from.
Yeah. It's not because his point of view has changed or he's been convinced of anything. It's very pragmatic for the moment. So I would not rely on him. At the risk of being accused of cultural appropriation, I think that it is best to use the words of Audre Lorde in a completely different context, if you don't mind my saying that her words, the master's tools will never dismantle the master's house.
Yes, indeed. Listen, I loved her. She was a darling, and she would be glad to be quoted.
Okay, so that's what we're dealing with.
Yeah.
Notwithstanding that there is an occasional change.
But it's not
people
standard.
Are who they are, and the judges are human in some respects. And they're called upon to interpret the Constitution and statutes. So when you have these people who are the originalists, and they're saying, well, it has to be the way it was written in the Constitution, and we know the Constitution doesn't mention Facebook. You're kind of stuck.
Yeah.
Or the Second Amendment.
Right. I mean, yeah, which may have been in fact about slavery and slave patrols, but that's
and militia. Yes. So, and that type of thinking does not really reflect the American public, but also it's people have taken on. I don't know if this is a reflection of a kind of libertarian thing, but now you hear people talking about their constitutional rights and their liberties, which I think, are often misunderstanding. And they don't. For example, someone called me recently about something offensive in her neighborhood that affected her personally, and she said, "Well, I think it's unconstitutional," but it had nothing to do with any constitutional privileges. It's really not about that. It's about interpretations of the Constitution and statutes, which is why the justices can't really be replaced so far by computers. If it was just interpreting the law, if it was just reading the law, what does the law say? The law very rarely tells us exactly what is meant. So it's interpretation, and it's the people who are going to do this interpretation that matter. We know that the new justice, I can barely say her name, she's already said that abortion is barbaric in all cases. Well, we know what that means about the interpretation, but Ruth Bader Ginsburg said it very well in a case that most people don't think about too much. The case where a 13-year-old girl was searched in her private parts because she had a Tylenol tablet. They were looking for, and the other justices laughed at her. Well, what was so terrible about that? And Ruth said, they don't it's the case of Savannah Redding. Yeah. They've never been a 13-year-old girl. And
therefore they were not qualified.
And therefore they don't know. But
maybe we should put some 13-year-old girls on the court.
Right.
Speaking of Ruth, there are people who feel, oh God, why didn't she retire earlier? And then there are other people who say she had a complete right to stay as long as she wanted. What is your feeling, if any, on that?
Well, I did feel that, yes, she has a complete right to stay. And I understand that in his first term, Obama did invite her in to talk about other things, including whether she might retire. And she obviously did not. And I thought that was right. But now, seeing what has happened, I do think nobody beats pancreatic cancer.
No.
And so now I'm thinking that from the time that she knew that she had pancreatic cancer, her days were numbered.
But that was late after all, Emily. She had thought, she had, like the rest of us, assumed that she would be she would leave and her place would be taken by someone appointed by the first woman president. That's what she was waiting for, Hillary.
Right.
And
that's
so
right. That's
from
right.
that time on, and then the diagnosis of pancreatic cancer, that's where the question marks begin.
Hillary, of course, I know, everybody knows, was instrumental in Ruth's nomination in the first place.
Exactly.
By Bill Clinton.
That's right.
And who knows who she would have put on the bench had she been elected, giving Ruth an opportunity to slip away. But, by the way, the discussion that's been going on, I couldn't really bear it, but where the new justice was asked questions that she said, well, I can't really answer how I would rule, though everybody knows that, for example, Trump had said he would only choose justices that were anti-choice.
Correct.
To use one example. But actually, Hillary did that in her campaign, too. I mean, saying she will only choose pro-choice judges.
Right.
So it's the opposite side of the coin.
I always thought
But-
it would be poetic justice if Anita Hill were appointed. But I realized...
Absolutely. I thought Anita Hill should run with Biden as vice president, making the greatest political apology in history. But we haven't heard from Anita Hill recently on this election.
She did say she did say earlier she did not accept his apology because it was made so superficially. But then later on she said, "I am nonetheless voting for Biden-Harris," and made that very clear in a public statement.
Okay. Well, good for her.
Yeah, she's a stellar creature. Oh, Emily, this has been so interesting, and thank you. It hasn't solved anything, but nothing solves anything at this point, and all we can do is be vigilant and ourselves and on guard and keep fighting. And I'm so grateful that you're there. I'm just really, and may we return to you if we need to.
It would be my pleasure anytime, and any excuse to talk to you. And any excuse to talk about these subjects.
Oh, brilliant. Well, you're fantastic on these subjects. So thank you again for being with us, and we'll just hold tight until after the election.
Okay. Stay strong and be healthy.
Yes, you too.
Thank you.
We have to pause here briefly for our final break, but then I'll return with those fighting words.
For the smartest talk about news, politics, sex, books, religion, race, and more, it's Women's Media Center Live with Robin Morgan. Audacious, witty, provocative, informative, and fun. It's Women's Media Center Live with Robin Morgan. Talk radio with a brain.
Toward a more perfect union is a patient phrase, but it's a phrase composed of fighting words. (1789). The Constitution of the United States grants the states the power to set voting requirements. States limit this right to property-owning or tax-paying white males, about 6% of the population. 1790. The Naturalization Act allows free white persons born outside the U.S. to become citizens. However, due to the Constitution granting the states the power to set voting requirements, this act and its successor Naturalization Act of 1795 do not automatically grant the right to vote. 1792 to 1838, free black males lose the right to vote in Pennsylvania and New Jersey. 1792 to 1856, abolition of property qualifications for white men from 1792 in Kentucky to 1856 North Carolina during the periods of Jeffersonian and Jacksonian democracy. The 1828 presidential election was the first in which non-property-holding white males could vote in the vast majority of states. By the end of the 1820s, attitudes and state laws had both shifted in favor of what was called universal suffrage, but actually was universal white male suffrage. Voter turnout soared during the 1830s, reaching 80% almost of adult white males in the 1840 presidential election, and making poor white male voters a huge part of the electorate. The last state to abolish property qualification was North Carolina in 1856, resulting in a close approximation to universal white male suffrage. But tax-paying qualifications remained in 5 states in 1860: Massachusetts, Rhode Island, Pennsylvania, Delaware, and North Carolina. They survived in Pennsylvania and Rhode Island until the 20th century. 1868, citizenship guaranteed to all male persons born or naturalized in the United States by the 14th Amendment to the U.S. Constitution, setting the stage for future expansions to voting rights. 1870, the 15th Amendment to the U.S. Constitution prevents states from denying the right to vote on grounds of race, color, or previous condition of servitude. Disenfranchisement after Reconstruction began very quickly. Former Confederate states passed Jim Crow laws and amendments to disenfranchise African American and poor white voters through poll taxes, literacy tests, grandfather clauses, and other restrictions applied in a discriminatory manner. During this period, the Supreme Court generally upheld state efforts to discriminate against racial minorities. 1887, citizenship is granted finally to Native Americans, only those who are willing to dissociate themselves from their tribe by the Dawes Act, making those males technically eligible to vote. 1913, direct election of senators, established by the 17th Amendment to the Constitution, gives voters rather than state legislatures the right to elect senators. 1920, women are guaranteed the right to vote by the 19th Amendment to the Constitution. In practice, the same restrictions that hindered the ability of non-white men to vote now also applied to non-white women. 1924, all Native Americans are granted citizenship and the right to vote through the Indian Citizenship Act, regardless of tribal affiliation. By this point, approximately two-thirds of Native Americans are already citizens anyway. Notwithstanding, some Western states continue to bar Native Americans from voting until 1948. 1943, Chinese immigrants given the right to citizenship and the right to vote by the Magnuson Act. 1948, Arizona and New Mexico become the last states to extend full voting rights to Native Americans, which had been opposed by some Western states in clear contravention of the Indian Citizenship Act of 1924. 1961, residents of Washington, D.C. are granted the right to vote in U.S. presidential elections by the 23rd Amendment. 1962 to 1964, a historic turning point arrives after the U.S. Supreme Court under Chief Justice Earl Warren makes a series of landmark decisions which help establish the nationwide electoral system, so-called one man, one vote, in the United States. In February 1964, the Warren Court rules in Westbury v. Sanders that districts in the U.S. House of Representatives must be approximately equal in population. In June 1964, the Warren Court rules in Reynolds v. Sims that both houses of the electoral districts of state legislative chambers must be roughly equal in population. In 1964, poll tax payment is prohibited from being used as a condition for voting in federal elections by the 24th Amendment. In 1965, protection of voter registration and voting for racial minorities, later applied to language minorities, is established by the Voting Rights Act of 1965. This has also been applied to correcting discriminatory election systems and to districting. It was crucial and central to enfranchisement, the Voting Rights Act of 1965. 1966, tax payment and wealth requirements for voting in state elections are prohibited by the Supreme Court in Harper v. Virginia Board of Elections. 1971, adults age 18 through 21 are granted the right to vote by the 26th Amendment. This was enacted in response to Vietnam War protests, which argued that soldiers old enough to fight for their country should be granted the right to vote. 1972, requirement that a person reside in a jurisdiction for an extended period is prohibited by the Supreme Court in Dunn v. Blumstein. 1986, U.S. military and uniformed services, merchant marines, other citizens overseas, living on bases in the United States, abroad, or aboard ship, are granted the right to vote by the Uniformed and Overseas Citizens Absentee Voting Act. 1996 to 2008, 28 U.S. states changed their laws on felon voting rights, mostly to restore rights or to simplify the process of restoration. State laws on felony disenfranchisement have since continued to shift, both curtailing and restoring voter rights, sometimes over short periods of time within the same U.S. state. 2006, the Voting Rights Act, the crucial one, of 1965 was extended for the fourth time by President George W. Bush, the second extension of 25 years. But in 2013, the Supreme Court ruled in the 5-4 Shelby County versus Holder decision that Section 4B of the Voting Rights Act is unconstitutional. It's been a long road getting here. More to go. I hope you vote. Oh, I hope you vote. Those are my fighting words. Add yours on Twitter, and remember to tag us at WMC Live and use the hashtag #FightingWords. And that's our show for this week. You can follow me on Twitter, Facebook, and now Instagram at The Robin Morgan, and you can check out my blog at robinmorgan.net and find my latest book of poems, Dark Matter, and my brand new novel, Parallax, wherever books are sold. Opinions expressed on this program do not necessarily represent the Women's Media Center. Here's the family for Women's Media Center Live. Executive producer as well as founding and sustaining sponsor Regina K. Scully. WMC president and co-executive producer of this program, Julie Burton. I'm Robin Morgan, your producer and host. Thank you for being with us. Join us again next time on Women's Media Center Live.